The judiciary is one of the three co-equal branches of government. It must be adequately funded.
That was the powerful message delivered at a symposium on state courts in September, sponsored by the University of Kentucky College of Law, the Kentucky Law Journal, LexisNexis, the National Center for State Courts, and the American Bar Association.
The state courts are the nation's preeminent instrument for the ordinary administration of criminal and civil justice, the great cement of society where over 96% of our country's litigation is resolved.
We've all learned to be resourceful and to live within our means, to change, to evolve, to re-engineer. But state courts are running out of options during the Great Recession.
We say in the United States, we get what we pay for. And while there's still heat in our courthouses, how many courtrooms are now dark for days each month or all together? While we don't have defendants sit in cages in courtrooms, in how many courthouses across the country is there going to be a security problem because they can no longer afford security staff? How great will the problem need to get before we really have compromised the rule of law?
The symposium's 3 panels focused on business, technology, and judicial independence. The problem: how court layoffs, closures, and vacancies have led to delays that undermine access to justice. One result: the business community is starting to look elsewhere.
These cuts to the judicial branch could not come at a more inopportune time. America's businesses and job creators are faced with a lot of uncertainty.
Business disputes don't often come to public courtrooms anymore. That's not good long term, but it's a reality we're dealing with, and some of those business disputes don't come to our courts because we're too slow.
Technology is one tool courts are using to handle increasing civil and criminal workloads.
So access through court websites, which is now becoming the old media, is being replaced by the new media where there's two-way interaction with the public.
We give written jury instructions. Why can't they have tablets and have the jury instructions on a tablet? I mean, we've got to start thinking about how to embrace these things.
Our branch of government has to lead change, because if we don't lead the change, somebody will lead the change, and it will more than likely make us non-functional and irrelevant.
And yet, efficiency and innovation aren't enough. State courts are often forced to justify their functions and their relevance to the other 2 branches of government. But should they have to, and at what cost? That's the challenge of judicial independence.
Our court system brings in over $1 billion in fees and fines. But the court system was not getting that money in order to help it operate.
And judiciaries aren't a very powerful special interest group. They're not able to donate money to influence the legislative process. They can't marshal voters.
If our legal system isn't accessible, then it can't be just and it won't be fair, a message echoed in speeches at the symposium.
This is not the time for any state to give its residents ration cards for justice. State courts are the legal equivalent of the emergency room. This audience knows that it matters, it really matters, whether a case moves expeditiously through the system. It matters to the business damaged by the theft of its intellectual property. It matters to the crime victim seeking justice. It matters to the defendant on trial, or the injured worker with mounting medical bills, or the parent who has been laid off and needs to modify a child support order. It matters to lawyers trying to manage their caseloads, and it ultimately matters to the public's perception of its government.
That courtroom must be open to protect families. That courtroom must be open to validate and protect contracts for business, including small business, which is the backbone of this country. That courtroom must be open to keep the wheels of justice turning. That courtroom must be open to defend our individual rights, to prove again and again that we continue to be a free society. There's no more significant responsibility for us as officers of the court than standing up for our courts, speaking up for our courts, going out together to awaken the American public to understand that these courts, their courts, are the key to constitutional democracy. Because otherwise, no courts, no justice, no freedom. Thank you all very much.